Hi, I'm Joe Sorge, and welcome to the Family Law Report, where we examine the problems and challenges facing our family law system. We're lucky today to have a veteran of our military, Bob Balick, who will speak to us about the subtleties of how military retirement pay is handled by our divorce courts. Bob, thank you for agreeing to be on the Family Law Report.
You're welcome. Glad to be here.
So, Bob, please explain to us the difference between a pension one might receive from a private company and retirement pay from the military.
Retirement pensions at a civilian company are contributory and they're deferred compensation. They build cash while the employee is working, whereas in the military, nothing happens in the way of cash until the person retires, because military retired pay is current income. The only thing that accrues is the ability to ask to be transferred to the retired reserve. And by law, you can't do that until you either have or will have at least 20 years and 1 day.
Are you saying that if you were to leave the military before your retirement pay is vested, that you'd get no retirement pay?
That is correct. And actually vesting isn't a true term for the pay. The only thing that vests is the ability to ask for transfer to the retired reserve.
Compare that to a firefighter who's employed by a municipality. How's their retirement pay treated in a divorce?
They contribute to it just as their employer, in this case, the governmentality. It does accrue value. It can be computed as to its value at a certain point in time. In the military, let's say if you decide to leave the military with 19 years, 11 months, and 20 odd days, there's nothing there. And even after you cross the 20-year point, unless you're approved for retirement, there still is nothing, but you are put on reduced pay called military retired pay. Military retirees are still on the payroll. They still have to comply with what they call the UCMJ, Uniform Code of Military Justice. Military retirees have to maintain U.S. citizenship. If they denounce it, they lose retired pay automatically. They can live overseas in a foreign country, but still must maintain U.S. citizenship. If a military retiree is convicted of a felony and is incarcerated, that's another termination point for retired pay.
Does the military itself have an obligation to share retirement pay with a former spouse?
Only by court order. And there are things that enter into that. The marriage and the service time must overlap by at least 10 years. If that isn't specified in the divorce decree, the retired pay office goes back to the originating court and say, you either need to clarify this or we can't accept it. I found that there's probably about a 50% break between the states that say, okay, since the retired pay office won't accept our court order because you weren't married for 10 years or more while you were in the service, you need to put a check in the mail to your former spouse. And that's basically alimony. The other 50% of those states that have that situation come up say, well, the federal law says 10 years or more, we can't make you do anything, so your retired pay is safe.
What happens to the income stream to the former spouse if the retiree is no longer qualified to receive the retirement pay?
Only in one case, where if the military retiree is convicted of domestic violence against the former spouse and their children in common collect all the retirement benefits of the military retiree who loses all the benefits as a punishment for domestic violence.
When you say convicted of domestic violence, is that in a criminal court with a jury or in a family court with only a judge?
Can be either. The important point there is conviction.
I've seen family courts place a value on a college or professional school degree and then set alimony and child support levels based on the earning potential of that degree, even if the recipient of the degree has joined the Peace Corps. Does that apply here?
Military retired pay cannot be computed because it depends upon the rank of the individual when they are actually transferred to the retired reserve. And at some point in time, should that person not go by the rules or whatever, then military retired pay can be either cut back or totally terminated.
Well, that's a logical argument, but I haven't seen much logic used in family court. Did the lawyers try to assign a value to the length of time you served in the military?
Both lawyers said to me, well, this is the judge's court and he makes the law. I said, so when is it legal that a judge can legislate from the bench? And they both said he can't. I said, then, let's follow the law as written here. We're going by the rule of law, not the rule of the court.
The rule of law? Good luck trying to get that to apply in family court. So what would you like to see done to clarify these issues surrounding military retirement pay?
We would like to have military retired pay divided under the Uniformed Services Former Spouses Protection Act, or the USFSPA, be termed alimony, because the only way that that division of retired pay ceases is by the death of either the military retiree or the former spouse. If the former spouse passes before the military retiree, the amount that's garnished isn't garnished anymore and basically returns to the military member in their paycheck.
Sounds logical. About how many people are affected by these vague laws pertaining to military retirement pay?
Right now, the Retired Pay Office is running close to 100,000 accounts of former spouse accounts that they're garnishing retirees' retired pay. We're estimating that there's probably about an equal number, about 100,000, that pay their former spouse direct, where their account isn't serviced by the Retired Pay Office. So there's probably 200,000 military retirees who are paying their former spouses because of the USFSPA.
Well, I wish you good luck in trying to get this all sorted out. If I have it right, you only have to overcome the vested interests of Congress, the military, the family law lawyers, and the spouses of former military employees. As you might say, I think you've got an uphill battle in front of you. Well, Bob, thank you very much for your time. I appreciate it.
I appreciate it too.
Well, there we have an example of rigid military codes conflicting with our typical family court autocracy. Another example of why I think alimony should be governed by private agreement rather than by statute. I'm Joe Sorge, and this is the Family Law Report. Thank you.